you can be a monopoly. You just can't be a monopoly where you're now using that power to the detriment of competition.
Welcome to Queen City News Plus. We got order in the court today, and of course, I am Brien Blakely.
And I'm Chief Legal Analyst Khalif Rhodes.
Khalif, always good to see you. I know you're trying to get some stock work in there. That wasn't very good news right before we went on air, but we do have some good news before we get into our three topics today for our legal discussions when court will be in session. And your son, by the way, he wound up being number one in the state for a little bit.
Number one in the state,
yeah.
150, Class A, 8A, I should say. So, proud moment. Extremely excited to see him maneuver in that space, which is just a new place. You know, JV to number one is not an easy track.
That is commendable for sure.
That part in the middle is the hard part. So I'm glad we're out of the middle part, but just grind it, man.
You can come in bouncing on at least that step for sure. And well, let's talk about our cases today. We got three of them. You know the deal here. First one we're going to talk about, it's looking more and more likely that the president's powers are going to be expanded due to the Supreme Court. They are considering overturning that 90-year precedent over which federal workers, that any president can have the ability to fire. And it really stems earlier this year, Khalif, from when President Trump fired the Federal Trade Commissioner, Rebecca Slaughter. And she, after she got removed from her position, she is now suing the Trump administration and White House, arguing the federal protections prevented him from doing that. But the justices are now considering whether this was a legal move and he can have these powers going forward to fire any federal worker. Consequences of this? Forward?
This is a really complicated question that's attempting to be, I guess, dumbed down, and not for the viewers, but just for the court and the Trump administration. So the easiest way I can say it is, does the president have the authority to remove the heads of an independent agency without cause? That's the question presented. And every time the Supreme Court listens to a question presented, or to a case, there will be a question presented. So the petitioner will say, hey, we believe this is a constitutional issue. We believe this is an issue that the court should address. And when you submit your case for them to grant cert or deny cert, it's typically will be where you'll have a question presented. The question presented in this case is, does the president of the United States have the authority to remove independent agency heads? And so when you mentioned a 90-year-old case precedent, that Humphreys case is 90-plus years old, and that case said that the president does not, cannot, should not remove a person and must not remove a person from an independent agency unless they are doing it for cause. He did not mention cause when he removed a FTC woman. What he did was say that your thought process, your political ideology doesn't connect to what I'm attempting to do, and because of that, we're removing you from your position. Specifically, not because you've done something, disconnecting from your position, not because you've done something that is, a misstep, an egregious, some type of, malpractice. No, what you've done is you've just disagreed with my recommendations. And that goes to the very question, did Congress create these agencies so they could be independent, so they could be apolitical, so they could remove influence from a political party, and they could do the work, that quasi-judicial, quasi-legislative work that they were entitled to do? This court seems open to saying, yes, the president can remove them without cause. If you listen to questions today, oral arguments like I did, you can get the tone from the justices that are in the majority that they are willing, ready, and able to remove this.
And for the court of law, for the rule of law, you're striking down a 90-year-old precedent. After hearing some of the arguments into court, what do you think this? Why do you think this is more of a conservative-leaning Supreme Court that wants to expand those powers for President Trump? Any other president going forward also has this situation too. So what does this do for the rule of law going forward for presidential powers?
What's good for the goose is good for the gander. So it's good today as a Republican. If you got an R next to your name, you're happy that the Republican president gets the opportunity to handpick and to remove agency heads and people that sit on these agencies. And so I have to break it down for folks at home so they recognize what happens now. These people are appointed by the president. And then once they're appointed or placed in there by the president, they sit for terms, sometimes 4 years, sometimes 6 years, depending on the term that they're sitting in, depending on the agency. And so they overlap. This woman that's being removed, she was appointed in Trump's first term, went through Biden's entire term, and still was there. And then Trump 2.0 presidency comes through and they attempt to and have removed her. So when you're looking at their terms, typically they would not be removed unless there was some type of misstep in the office. So what the president is attempting to do is say, well, you know what? I want to be able to remove these folks. So you ask, what does it do for the rule of law? It throws up into question a number of things. Do we have three co-equal branches of government? Can Congress, appoint and create these agencies, and will they truly be independent? And going forward, the next president can now say on day one, I'm going to remove all of these folks that you just put here. I think that is going to be trouble. Think about what these agencies do. The FDA, they're talking about the Food and Drug Administration, FTC, Federal Trade Commission. These are agencies that have a individual large impact on your day-to-day life. This isn't something that's, it's just out there, it doesn't affect me. These are going to be folks that make the rules, that make the recommendations, that impact the businesses that touch you, that impact your day-to-day working.
One of the things, too, is that you're talking about you can fire any employee. They could fire them because they didn't like them. They didn't like them positions on certain things. You're talking about the Federal Reserve, Jerome Powell. What would, if this were to go through, if the Supreme Court were to rule in favor of those expanding presidential powers, could that possibly happen with Jerome Powell and the Federal Reserve?
I think the Fed chair is protected. The court today in oral argument asked a question to the Solicitor General, and he responded that they believe that is an agency that is hands off, that should not be touched and would not be touched. When you're talking about these independent agencies, they aren't making the argument for.
Well, then it's an arbitrary, I can do who in this agency, but I'm not going to do in this agency. Do you have carve-outs in the decision or something like that?
It seems like that's what it will be, that the court, if they make a decision the way I think it will go, that they will say that the president has the power to remove any of these folks that serve on these independent agencies, and excluded from this opinion is the Federal Reserve, any of the governors, president, and the chair, because I think it would have a significant impact, not just on the United States economy, but global economy. And that impact is something that the Supreme Court, while they should not be contemplating it, I know it will be in the back of their minds. I know the president is contemplating that. That's why his own Solicitor General made sure to make the argument that, no, we're not talking about when we say that the president can remove anybody, that he can remove the federal chair. They are not just independent. They are extremely independent.
Yeah, and certainly one of the things that we need to be following right now, but a decision, when's that going to be expected? Is that something that's going to be handed down by the Supreme Court later this summer, like in June or July?
I'd anticipate that probably between 4 to 6 months we should see some type of decision from the court or arguments, and then there is a break, and after that break you normally would get it. So I'd say in that 4 to 6 months time frame you'd see that, but that's why it's important to listen to these oral arguments so you can kind of see where the court's tipping his hat. And listening to today's argument, they're tipping their hat to a ruling against the Humphreys decision, which was 90 plus years ago, and allowing this current president, President Trump, to remove anybody from any agency at any time. Yeah,
the further erosion of the Constitution and the separation of powers. All right, we're going to keep following that one for sure. And also coming up after the break, we're going to be talking about Ice Block. They're in the news, as they're going to be they're suing right now themselves over being taken off the apps. We'll have more on that with Khalif and Brien. You're watching Queen City News Plus and also on Order in the Court. Welcome back to Queen City News Plus. You're watching Order in the Court with Khalif and Brien right now. And when we went to the break, we were talking about the latest thing that is our next subject, and that's the iPhone app of Ice Block. You remember that? That's the app that would flag sightings of U.S. immigration agents when they were in town. They're suing the Trump administration for free speech violations, and alleging that U.S. Attorney General Pam Bondi used her state power to force Apple to remove them from the app.
You got a lot of moving parts here, so this would be a great law school question. Is this an intrusion in infringement and a chilling of Ice Block's First Amendment speech? That's what Ice Block is attempting to argue. And I think there will be a number of questions and concerns when attempting to have a court unpack that. And so the first thing is, well, what action was taken? If there was state action taken, then yes, you'd have a First Amendment question and concern. But if there was no state action, then you don't have a First Amendment question. And so is the removal from a private company, a private platform, a state action? Well, if they did it on their own, no. But if they were influenced, removed, persuaded, encouraged by Pam Bondi to remove them on behalf of the federal government, then you may have opened up the door for state action. The argument that the government would say is that this is just Apple enforcing its own policies, its own platform safety rules. One of the things that Apple sent out to this developer was that your app is being removed because it violates our rules. Specifically, you've endangered law enforcement with this app, and because you've endangered law enforcement with this app, now we have to remove you. So Apple sent this out. The government is saying this wasn't our action. This is state action. For you to have a valid First Amendment claim, there has to be protected speech, and that speech has to be infringed on or chilled by the government. And so if you have no state action, then it's not even an opportunity for this to be a First Amendment claim. The other thing I'd say is, because the reason why I say this is a great law school example, because in law school they will want you to catch that part, because most folks would just jump to the analysis of the First Amendment. Is there a compelling public interest? Is it narrowly tailored? Are we going through the strict scrutiny test of what's required for a First Amendment challenge? But before you can even say, we'll go through the steps, you need to know, was it state action? And if you have like one of those flow charts, if there's no state action, you don't even have a First Amendment cause. But let's suggest and say that, hey, there was state action, that the government, due Pam Bondi's communication with Apple, did now chill this person's this app speech. Then you go, well, is there a compelling government interest? Is it nailed?
Pun intended, by the way, on Ice Block, right?
Say that again.
You said no to chill them. No pun intended.
Right. Yeah. Well, there's definitely pun intended by Pam Bondi, right? So what I'd say is, if you go through the strict scrutiny test, what's the first thing you want to say? Well, is it narrowly tailored, and is it a compelling public interest? Well, what's the compelling public interest? The easy answer for Pam Bondi is to protect officer safety. We don't want our officers going on the street and being attacked, being harassed, being intimidated. We don't want folks following them, trying to see where they're popping up. And so they'll argue instantly government safety. And if they can argue that, I think a court will be receptive to that. However, I don't think we get that far. I think this is not government action. And because it's no state action, I think it's probably going to be dead on arrival.
One of the things, too, the Texas-based developer there for Ice Block, they're trying to protect themselves in this lawsuit, is that from unlawful threats is what they're calling against Attorney General Pam Bondi, also the Secretary of Homeland Security, Kristi Noem. You got Acting Director Todd M. Lyons and the White House Board Czar Tom Homan. They want to criminally investigate and prosecute the developer for his role in putting that app on Apple.
And I think this one also is going to be hard for them to be able to get the court to follow their rationale, because you have to have an injury or an injury in fact. And so if you're saying, hey, I want the government to stop threatening to prosecute me, is what their argument is, the court would say, well, your injury is non-existent because it's the potential threat of prosecution. Now, Melissa's prosecution, different. They've brought this case against me unjustifiably. There's no case. You can file a lawsuit and ask the court to intervene there, but the court on its own is not going to make a decision to tell them to stop potentially bringing a claim against you, because we don't do anticipatory claims. This has to be something where you've been injured. You now are trying to be, made whole based on the injury that the government has done to you.
All right, coming up, we're going to leave that one there, but coming up after the break, we're going to be talking about NASCAR, big antitrust trial that is ongoing right here in Charlotte. Michael Jordan took the stand last week. Other people are taking the stand this week to talk about the money and how much is involved in that. We'll talk about that a little bit more. We're coming up on the other side of the break. Here you're watching Queen City News Plus with Khalif and Brien on Order in the Court. Welcome back to Order in the Court on Queen City News Plus. Khalif and Brien, and Khalif, we were talking about one of the big, huge case, monumental case that could shape NASCAR or reshape NASCAR going forward. And that's the antitrust trial involving Front Row Motorsports and 2311 Motorsports, which is Michael Jordan and Denny Hamlin, the co-owners of that. And it's talking about the charter system. Michael Jordan was in court on Friday talking about the stuff that he has endured. We've had Denny Hamlin on the stage. Today, we had economist Edward Snyder talking about the damages they seek in this case, which could be great in the tune of $365 million.
I like all of that you laid out. And when you talked about this case could reshape NASCAR, the first thing I thought was, well, the tracks aren't going to be reshaped. We're still going to be doing left turn, left turn, left turn. So let's get that clear. That what they're attempting to do is reshape the structure in terms of these charter systems. Is it going to be similar to how you have the NFL, NBA, Major League Baseball, Major League Soccer, where these franchisees are active participants in the financial
Is it
benefits?
a monopoly? That's
right.
The big question.
Right. Well, not just that, because it is, but is it a anti-competitive, antitrust violating monopoly? You can be a monopoly. You just can't be a monopoly where you're now using that power to the detriment of competition, where now you're saying, because I'm a monopoly, I'm the big brother, and you can't play with my ball unless I allow you to play. That's what the court is doing now. And the court has already spoken and said, yes, you guys are clearly a monopoly within the space of sports racing in North America. But I think through the testimony, what NASCAR is going to have to defend, and what Front Row Motorsports and 2311 is attempting to show, is that they have been anti-competitive, that they have attempted to limit and stifle competition. Denny Hamlin took the stand, talked about a number of things. His personal investment of $10+ million, on the hook for $45 million total. Those are the types of things
he was saying that if one sponsor, if he take that away, they lose all kinds of profits.
Yeah, that these are,
and it's because of the fees that they've instituted. NASCAR instituted this charter system just last year.
This is the situation where they're attempting to say that we're basically living check to check. And you don't anticipate a owner of a sports team, to say that hey, you see me on the big stage, that there's $1 million, if not $1 billion contracts negotiated for television deals and sponsorship deals, but us, the teams, are losing money. What does NASCAR come back and say? Well, on December 4th, NASCAR got a chance to come out there and talk about some of those things. Claims it lost $55 million on the Chicago street race. Claims it lost $13 million on the Coliseum Clash, $6 million in Mexico. These are things that they're saying that NASCAR is talking about that they've lost over a number of years. But Front Row comes back out and says the same thing. I've lost $70 million over 11 years.
Some of the people also who know the sport in NASCAR argue, well, why are you going to Chicago? Why are you going to Mexico?
That's
why are you
true.
going to Coliseum?
Know where your base is.
Decisions on some of those races have been questionable, is what a lot of people have been talking about.
I think that is extremely well. I'd say the same thing, that if you're going to try to blame profitability or lack thereof on the system, it can't be on the owners as well. That this has to be on some part the France family and what they're doing in terms of the leadership and direction of NASCAR. But to their point, to Michael Jordan's testimony that happened on December 5th, he doesn't want to harm NASCAR. And it's not my goal to try to break or, hurt NASCAR. The goal is to try to ensure that these owners are profitable, that they know what they put money in, that the investment that they put in, they'll get a return on the investment later down the road.
Some revenue sharing.
Right, revenue sharing. But then also, it's just like any investment. If I put money into something, I want to know that it's mine. So the charter system, because it's revocable, because at any time they can take it away from you, the owners are saying, well, what's the benefit for me investing in a team, growing a team, making it, competitive and making it be able to be productive over the years, for you to only be able to say, well, someone else came offering more money and now we're going to give them your charter. That's what they're facing right now. That's why they say it's anti-competitive, and that's why Michael Jordan in 2311 refused to sign that charter. But looking at his testimony, I think it was twofold. First of all, you got Michael Jordan sitting up there, so you've already fanning over him as a person that was in the jury box waiting to get selected. But now you get an opportunity to hear from him, and you're mere feet away from this person that in the state of North Carolina, if not the world, obviously everyone knows who he is. And so this is a person that's larger than life. And so you had to hear from him as a plaintiff, as an owner of the team, but you also wanted that, make it a personal connection. You want to make sure that they can say, hey, even though he's this legend, he's still an owner, still a person, and he's still being harmed by this anti-competitive process that is their fault.
Now, one of the things, too, we're shooting this on a Monday, taping this, so you see this at a lot later date for some of you. But today in court, we're told that the judge was getting very frustrated by how the pace of this trial is going. It's just not moving along. What are your thoughts on that as a legal you're a man yourself who's always in court?
Have you ever seen the movie Grumpier Old Men, right? I think that is the best way to describe some judges, and that's not a knock at this judge. It just depends on the temperament of the judge, right? And so the goal is that the judge is the guy, the man or woman that's in the courtroom calling balls and strikes, right? And it's their obligation to ensure that nothing gets passed that shouldn't, right? That jurors don't get improperly influenced, but then that you hold the attorneys to the schedule that they set. So at the beginning of a trial, before the jury gets impaneled, a judge will say, hey, how long do you anticipate this trial to be? And then one side may say 2 weeks. The other side may say 3 weeks. And so the judge normally will go with the larger side. So when they talk to the jury, they'll say, hey, ladies and gentlemen of the jury, this trial is expected to last 3 weeks. So now if the judge is a week and a half in and they're saying, hey, I'm recognizing that it's looking like you guys have 20 more witnesses, but you're only on witness number 2. And you're saying it's only going to take 3 weeks. Well, speed it up. So how do judges speed it up? Sometimes they're short. They'll say something like, move along, hurry up with your questioning. Like, they will try to allow you to try your case, but they also will try to ensure that you are consistent with the schedule that you've set. So if you're being inconsistent because you're asking 50 questions, repetitive type of questions of a witness that already have come out, that the jurors have already heard the answer that you want them to hear, the judge is going to say, move it along. We don't have to harbor here. Let's not hang out in this space.
Has that ever happened to you in court?
Not to me, but I've seen it happen a number of times in my most recent trial. It was a multiple co-defendant case. So other members, other attorneys that represented the co-defendants, oftentimes the judge would say, all right, go ahead and move along. Now, I'm pretty efficient to where I want to go. I know I want to ask 1 or 2 questions, to my point. I don't want to belabor it because I know jurors they're not listening that far. They can get lost in the 10 or 12 questions. If I need to trip someone up, if it's a really important witness, I'll ask a lot of questions. But if it's a witness that's, not extremely, important to the case, it's not a matter of material fact that, our case hinges on, I'm not just going to ask questions just for the fact of asking questions. If a judge feels that an attorney's doing that, they'll do that. And they'll say, hey, move along. That's enough time hanging out there. And an attorney that sees it will get the hint and say, well, thank you, Your Honor. Maybe ask 1 or 2 more questions and then move on. That lets a judge know that you know what you're doing. And that, again, the judge wants to not have to step on your toes. But if they feel like you're not holding up your end of the bargain in terms of pace, they'll pull your coattails.
Yeah, well, we are going to have to see when this one ends, and we'll certainly bring that back to you when it does for the decision going forward and a lot of those legal interactions. As we're going to wrap it up here, as you've been watching when the court is out of session right now with Khalif and Brien. We appreciate you.
Queen City News Plus. Just search Queen City News on your smart TV's app store.